Case on the docket 114076, in re John Andrew O'Leary. And I would announce that we do have two recusals with the Chief Justice and Justice Beyer. Sitting in for them today are the Honorable Tom Malone, who was introduced earlier on the prior recusal, and to make matters confusing, another Malone, the Honorable Michael Malone, sitting for the Chief Justice. Ms. Knoll?
May it please the Court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. As this Court is aware, this is an original action in attorney discipline. Mr. O'Leary has been in contact with me. On the 16th, he called and wanted to know why there was another setting. He believed that this matter had been disposed of, and I explained to him that we had to come before this Court to have the final decision because the hearing panel had recommended an indefinite suspension and I had requested a disbarment, and it was ultimately up to this Court as to what the final disposition was. He also called me this morning and indicated that he was not going to attend. So he was aware of it, and he did offer apologies for, quote, the mess that he had created. And I do believe that he was sincere with that apology. As this Court is also aware, he failed to appear here on a motion, on an order to show cause why his license should not be temporarily suspended. This Court did suspend him on December 12th of 2014. As far as the hearing goes, he did not file an answer and he did not appear for the hearing. The panel found that he violated 5.5A when he continued to practice law on a prior administrative suspension, and that he repeatedly engaged in criminal conduct, which was 8.4G, and Kansas Supreme Court 211B because he failed to file an answer. As far as aggravation, the panel found that he knowingly violated his duty to the profession and to the public to maintain personal integrity. He caused injury to the profession. He engaged in a pattern of misconduct. He committed multiple violations. At the time of the misconduct, he'd been practicing for more than 20 years, and he engaged in illegal conduct, including that involving controlled substances. As far as mitigation, they found he had no prior disciplinary record and that his actions were not motivated by dishonesty. In front of the panel, I explained that I looked at ABA Standard 7.4, which would suggest an admonition would have been the appropriate discipline, but because he failed to file an answer, because he had failed to appear before this Court on his order to show cause, and he failed to appear at the disciplinary hearing, I argued that disbarment would be more appropriate. And in the intervening time, as Mr. Hazlitt argued, this Court has issued the Barker decision on June 12, 2015, that indicates that when a respondent fails to appear before this tribunal, that can be considered another aggravating factor. And again, when you add that to all of the aggravating factors that are deemed admitted because there weren't any exceptions filed, I believe that the scales do tip towards a disbarment. And so I would ask that the Court order an interim disbarment and acknowledge the rest of the findings and conclusions in the final hearing report.
Ms. Knoll, it looks like the panel found that none of the violations were dishonest in any way or involved any dishonesty. Is that right?
That is correct.
So my question is, it looks to me like one of the respondent's convictions was for giving of a worthless check.
It was, I believe, pled down, if I'm remembering correctly, that it didn't have the element of dishonesty.
Okay, that was my question. Thank you.
They originally charged him with one count of delivering a check with the intent to defraud Rooks County, and he pleaded guilty to one count of giving a worthless check, which was a Class A misdemeanor. My recollection of reading the statute at that time, that it did not have the intent to
Didn't
defraud.
require a fraudulent element.
Correct.
Okay, thank you.
Any other questions? Any further presentation?
No, Your Honor.
I would just note for the record, as you indicated at the beginning, that Mr. O'Leary has not appeared, and I'll ask one more time, is Mr. O'Leary in the audience?
I have met Mr. O'Leary, and I can assure the court he is not present.
All right. With that, if there are no other questions, we will take this matter under advisement. That also concludes